No more easy path? UK nanny visa and family settlement shocking changes in 2025. If you're a nanny or caregiver hoping to work in Britain, or a UK family trying to hire or bring loved ones to settle, this video is your step-by-step guide to what's new, what's closing, and what still works. Let's make this simple. In 2025, the UK tightened migration routes in ways that affect both households and caregivers. This means there are now fewer sponsorship options, higher salary and skill thresholds, and more complex rules for family visas. If you're a nanny or au pair hoping to work in Britain, or a UK family trying to hire a nanny or sponsor loved ones, you must now carefully choose a clean, legal pathway that fits this new framework. If this topic interests you, make sure you hit that like button so YouTube shows this video to more families and caregivers who need the information. If you're new, subscribe for weekly UK visa updates and drop your situation in the comments. And here's the big question. With all these changes, is the nanny visa dream still alive in 2025? Stay with me, because what you're about to hear might surprise you. When people talk about a nanny visa, it's important to know that there's no visa literally called by that name. Instead, there are two main routes people mean: the Overseas Domestic Worker Visa and, in the past, the Skilled Worker Sponsorship route. The Overseas Domestic Worker, or ODW visa, is designed for nannies or household staff who have already been employed at least 12 months by a family outside the UK and are now accompanying the same employer into Britain. It is a short visa, maximum 6 months, with no extension, no switching into another category, and absolutely no path to settlement. Work is limited strictly to a private household. You must leave when your employer leaves or when your 6 months end. For some families, this works, but it's only a temporary solution. The other option, which used to offer longer stays, was skilled worker sponsorship. In theory, a nanny could be sponsored under Occupation Code 6114, work long-term, and after 5 years, qualify for indefinite leave to remain. But in 2025, things changed dramatically. From 22 July 2025, only RQF Level 6 jobs, that's graduate level or above, are sponsorable. Typical nanny or childminder roles, which sit at RQF 3 to 4, no longer qualify. On top of that, the salary floor jumped to around £41,700 per year, which is far above what most families can pay a nanny. And let's not forget, sponsorship requires the employer to hold a sponsor license, something private households almost never have. Put those three barriers together, and the practical result is that standard nanny sponsorship is effectively closed unless the role is redefined as a graduate-level position, such as a governess or private educator, paid at the correct salary and backed by a licensed sponsor. These changes didn't just affect nannies. They reflect a system-wide tightening on care roles. The government shrunk the eligible job list, closed overseas recruitment of care workers under the Health and Care Worker Visa, and banned new lower-skilled sponsorships from bringing dependents. The trend is clear: fewer pathways, stricter criteria, and less family migration through work routes. So, if sponsorship is mostly off the table, how can caregivers still work legally in the UK? Let's talk about practical paths that are actually open in 2025. The most accessible option is the Youth Mobility Scheme. This is essentially a working holiday visa for 18 to 30-year-olds, and in some cases up to 35, from partner countries such as Australia, Canada, New Zealand, Japan, Korea, Hong Kong, Taiwan, India under a variant scheme, and new additions like Andorra, Monaco, San Marino, and Uruguay. It's unsponsored, valid for 2 years, and allows the holder to work as a nanny or au pair without restrictions. There's no direct route to settlement from this visa, but for short to mid-term plans, it's a clean and legal way in. Another option is to look at candidates already in the UK with work rights. That include dependents of skilled workers, international students who can work up to 20 hours per week during term time, and of course people with settled or British status. For UK families, this is often the most practical pool of talent. Hire someone who is already allowed to work here. But legal employment requires more than just finding the right person. Since April 2024, live-in au pairs and nannies must be paid at least the national minimum wage, with an allowance for accommodation offset. Families must provide written contracts, track working hours, handle tax and payroll if it's a full-time job, and perform right-to-work checks. Importantly, visitors cannot work. Not even so-called trial au pairing is allowed. And for EU nationals, there is no special au pair visa after Brexit. They must have another valid UK status. So what about the dream of settling long-term? For nannies, it's challenging, but not impossible. The ODW visa and youth mobility visa do not lead to settlement. However, a nanny could eventually move into a qualifying RQF6 role in education or healthcare if they meet the skill and salary criteria. They might also gain status through the family route, such as marrying a British or settled person. Or, with enough lawful continuous stay, they could pursue the 10-year long residence path. It's selective and demanding, but it's the reality of the system in 2025. That's the picture for caregivers and families in terms of nanny work. But what about family settlement itself, bringing a spouse, partner, or child into the UK to live with you? Let's move into that. As of now, the minimum income requirement for sponsoring a spouse or partner sits at £29,000 per year. This was a sharp increase from the previous £18,600 baseline. There is active debate about this figure, with the Migration Advisory Committee suggesting a lower range of £23,000 to £25,000. But until a new policy is announced, families must plan for £29,000. English language requirements are also evolving. Spouses on the family route already need A1 English, but by the end of 2025, dependent partners of sponsored workers are expected to meet the same A1 standard. This is part of the Home Office's push for integration. Costs are another major factor. The immigration health surcharge rose to around £1,035 per adult per year. And with visa fees included, a first-time spouse application from overseas now totals roughly £4,500. Families should budget accordingly, especially if they intend to use priority services for faster decisions. The process itself is straightforward but strict. You start with an eligibility check. Is the relationship genuine? Does the sponsor meet the MIR or have sufficient savings? And is accommodation available? The applicant then needs to pass A1 English and in some cases take a TB test. Documents must include relationship evidence, payslips, bank statements, tenancy or mortgage details, and passports. Everything is submitted online, fees are paid, biometrics are taken, and then you wait for a decision. After arrival, the journey is 30 months, then an extension to 5 years, then indefinite leave to remain, and eventually citizenship if eligible. Looking ahead, the white paper proposals could extend the ILR horizon from 5 years to 10 years for most visa routes. However, partners of British citizens are expected to remain on the 5-year track. This would mean that family settlement stays relatively protected compared to work migration. But as consultations continue, applicants must keep an eye on policy updates. So with all that laid out, what should you do today to stay compliant and succeed? Let's pull it together into an action plan. If you're an overseas caregiver or au pair, check your eligibility for the Youth Mobility Scheme first and plan to arrive unsponsored. If your goal is long-term settlement, invest in qualifications at RQF6 level in fields like education or healthcare. Know your rights under UK minimum wage law and make sure you have proper contracts and payroll records. If you're a UK family hiring, recruit from youth mobility candidates, dependents, students within legal limits, and settled or British workers. Be extremely cautious about anyone offering visa arrangements unless it's a licensed sponsor offering a genuinely eligible role at the correct salary. Budget for national minimum wage, payroll, and possibly agency fees. And never skip right-to-work checks. Penalties for illegal employment are severe. A few quick FAQs before we close. Can you sponsor a typical nanny now? Practically no, the role no longer qualifies. Can a visitor nanny trial work? No, visitors cannot work. Can EU nationals still come as au pairs like before? Only if they already hold valid UK status. Can an ODW visa holder switch into skilled worker in country? No. ODW is non-switchable and non-extendable. The bottom line is this. In 2025, the nanny sponsorship door is nearly closed, but legal routes like the Youth Mobility Scheme and family visas still exist. For family settlement, the bar has risen, but the pathway for spouses of British citizens remains intact at 5 years to ILR. If this breakdown helped you, make sure you hit that like button so YouTube shows this video to more families and caregivers who need the information. If you're new, subscribe for weekly UK visa updates and drop your situation in the comments. I'll reply with tailored guidance.